Next, we're going to talk about vice crimes. These kinds of crimes are described as offending or offenses offending the sensibilities or morals. And I want to start with where they came from. Where do our vice crimes originate from? These crimes basically, like I said, offend sensibilities or morals. Since the first European settlements in North America in the early 17th century, governments in America have tried to regulate morality. The early colonists equated sin with crime. Such offenses as blasphemy, which shows a lack of reverence towards God, or heresy, holding a belief that conflicts with the church doctrine, and of course adultery, sex between two adults, whom of one which is married to another. These were all considered criminal acts and dealt with by sometimes even severe punishments. Actions and behavior that do not conform to accepted standards of what is considered right or wrong are called public order crimes. That's how they're described in the book, public order crimes. Social standards or morals can change through time, triggering changes in criminal law. The colonies had quote unquote blue laws, or these were so-called blue laws because they were printed on blue paper, and it was banning certain activities such as work on Sundays. Blue laws in Europe even enforced what people could eat or wear on Sundays according to their social status. Moral offenses decreased over time as the public accepted that certain forms of social deviation through still perhaps, even though it's still offensive to most, should not be considered a crime. Types of modern day moral offenses include the sale of obscene materials, certain kinds of sexual activity, drug and alcohol abuse, and gambling. Moral offenses often involve behavior between two consenting adults with no immediate victims to bring charges against. This is why moral offenses are sometimes referred to as these victimless crimes. The activity commonly involves one person providing goods, such as drugs, or services, such as gambling or prostitution, to another, with no one to file a criminal complaint claiming an injury. These are crimes simply because they were outlawed. Therefore, the criminal justice system must rely on informants, undercover agents, or surveillance equipment to detect or investigate these crimes. Critics of moral offenses claim they should not be considered crimes, but rather discouraged through better parenting and the community in other ways. Critics further claim that making these activities crimes create a black market that can lead to other more serious crimes, including violence. Others, however, contend that society as a whole is a victim of these deviant behaviors, as well as the friends and family of those involved in the activity. For example, drug use can lead to property crime by a person trying to pay for an expensive as well as destructive habit. Prostitution can cause the spread of disease and put the prostitutes in potentially violent situations. If moral offenses were allowed to occur in a community legally, then more serious criminal activity would likely follow, according to those who consider moral offenses a crime. These offenses should remain an illegal criminal activity, which in turn will protect the moral fibers of community. So let's talk about the specifics. The first one we'll talk about is drug crimes. As I said in Chapter 4, the government cannot punish someone for being a drug addict or abuser, but it can punish criminal acts involving drugs or controlled substances. All states and federal government criminalize the manufacture or cultivation, possession, sale, and use of specified drugs. Each state and the feds also have placed drugs into categories. They call these drug schedules. In New York, these schedules are laid out in detail under the public health law. You won't find it in our penal code and public health law. And I put a link on Moodle for you to review if you want to see the drug schedules. They're very detailed. But I want to talk about the federal drug laws. And I also provided a link on Moodle that condenses and explains the schedules outlined for the federal system as well. The Drug Enforcement Administration, DEA, which creates these designations, federal level. Just to kind of give you some background, I am not going to test you on the specific details of the drug scheduling laws. They're very convoluted and very detailed and comprehensive. Just want to point out how it works generally, point out some things. So the Drug Enforcement Administration creates these designations at the federal level, and most states kind of follow the schedule. Marijuana is in the same legal regulation category as heroin, which is a Schedule 1, which is the highest level. I'll tell you more about these in a minute. I just want to give you some background. To many people, as you can imagine, this is outrageous. Obviously, marijuana is nowhere as dangerous as heroin, and it's not more dangerous than Schedule 2 drugs like cocaine and meth. So why is marijuana Schedule 1? Well, the classification doesn't mean that the federal government thinks marijuana and heroin as equally dangerous drugs. The schedule reflects a more complicated system, one that accounts for a drug's medical value as much as the drug's potential for abuse. A harsh schedule also does not mean a drug is totally illegal. Criminal laws are guided by these scheduling systems, so they often take other factors into account. For marijuana, they do, leaving it as one that is less punished type of drug at the federal level as well as the state level, even though it's a Schedule 1. And opioid painkillers, as one example, are a Schedule 2, but they're legal for medical purposes. Still, a drug schedule is an important policy guide. A stricter schedule lets the DEA more stringently limit access to a drug and its supply, which can make a drug more difficult to research, which has happened for marijuana, limiting researchers' ability to study the drug for its medical value. And as a result, advocacy and medical groups have long contended that marijuana schedule is out of step with what's available for scientific evidence. But so what is this scheduling system? How does it work? How does the US classify illicit drugs? Under the Controlled Substance Act, the federal government, which is largely regulated per the regulations of drugs set forth by the DEA, they put each drug into a classification known as a schedule based on its medical value and its potential for abuse. To initiate a schedule, the DEA first asks if a drug can be abused. If the answer is yes, then it's put on a schedule. If the answer is no, the drug is left out. After that, the drug's medical value and relative potential for abuse are evaluated to decide what scale it lands on. The two big issues then are a drug's potential for abuse and its medical value. But Congress did not clearly define abuse under the Controlled Substance Act. But for federal agencies responsible for classifying drugs and abuse is when individuals take a substance recreationally and develop personal health hazards or pose other risks to society as a whole. To find medical value, a drug must have large-scale clinical trials to back it up, similar to what the Food and Drug Administration would expect from any drug entering the market. Schedule 1 drugs are deemed to have no medical value and high potential for abuse, while Schedule 2 through 5 substances all have some medical value but differ in ranking depending on their potential for abuse, from high to low. So some examples of drugs that are on each schedule. Schedule 1, the highest level: marijuana, heroin, LSD, ecstasy, magic mushrooms. Schedule 2, we have cocaine, meth, oxycodone, Adderall, Ritalin. Schedule 3, we have Tylenol with codeine. uh, anabolic steroids, and testosterone. Schedule 4 is Xanax, Valium, Ambien, and there's more on this list. I'm just giving you examples. Schedule 5 is Robitussin AC, Lyrica, or Lyrica. So in general, Schedule 1 and 2 drugs have the most regulatory restrictions on research, supply, and access, and Schedule 5 drugs have the least. So does the federal government really consider marijuana more dangerous than cocaine? This has been obviously the sticking point with regards to marijuana, and a lot of the studies on marijuana being healthy and being not healthy, but having medical significance is not coming out of the United States because it's very hard to research because it's a Schedule 1. To many people, one of the more bewildering aspects of the schedule system is that marijuana is a Schedule 1, the same category as heroin, and higher than cocaine and meth. But that doesn't necessarily mean the federal government, like I said, views marijuana and heroin as equally dangerous drugs, or that it considers marijuana to be more dangerous than meth or cocaine. Schedule 1 and 2 drugs are both described as having a high potential for abuse, which is a very vague description that doesn't rank drugs equally. I'm going to move on from the marijuana discussions. That always seems to be a sticking point, especially when I'm talking to clients who are charged with a drug crime. So, but beyond this scheduling system, there are different ways to handle somebody who is charged with a drug crime. And as I indicated earlier, the state criminal laws will designate the level of punishment, and generally marijuana is charged or punished with a lesser type of a penalty. In most jurisdictions, the manufacture of scheduled drugs is a felony. So people can be charged with manufacturing or growing, possessing, whether that's actual possession or constructive possession. We discussed that early on. I believe it was Chapter 4. Actual possession, it's on the person, on their or in their very close proximity. Constructive is it's under their control. So it could be in their bedroom under their mattress that they're the only ones who access the room. That's having control. Constructive possession. Distributing, selling, and trafficking. Those are all ways of charging drug crimes. And manufacturing of scheduled drugs is a felony, which elevates if there was a firearm present. Cultivation of marijuana, where you know or you're intending to grow, and it's going to depend on the amount being cultivated. In New York, it can be a misdemeanor, but it also can be a felony, depending on how much. And it's not found in the New York Criminal Penal Code. From up to this point, we've been talking about charges that are found under our penal code for cultivating marijuana or manufacturing drugs. It's found under our public health law, and I did put a link to our public health law on Moodle if you wanted to see some of the crimes under that body of law. Possession of drugs are graded. Possession is found under our criminal laws, as is distributing, selling, or trafficking. Possession of drugs are graded. It could be misdemeanor, it could be a felony. It's based on the quantity possessed and the drug's classification. It could be an A misdemeanor, knowingly or intend to possess, and it could be constructive possession. Remember this constructive possession, the item not on the person but within the area of control. It doesn't have to actually be on them. A Class A felony is possession of drugs, a large amount of cocaine, which is not a whole lot. Could be an ounce. Ounce gets you up there at that level. A misdemeanor could be a heroin residue on whatever is it. We've seen it on wrappings. We've seen, however it ends up being formulated, but a very minimal amount of heroin is a misdemeanor. So those are the levels. There's a number of drug possessing charges depending on what the classification of the drug is and how much. You have to have a lot of marijuana to get to the felony level. Distribution, sale, trafficking, felony, and it's usually a stiffer penalty than mere possessing. The grade is based on the quantity, again, the drug classification, and sometimes the location. If there is a drug sale going on school grounds, that's an elevated charge. As of right now, the feds do not intend to legalize marijuana. This is strictly the states that are doing it. They keep it as a Schedule I. It's very limited on the research that can be done on it. And the research that has been done, like I said, has been primarily out of the country. And why would you think all of this? Why is that happening? And I'm just going to speculate. Pharmaceutical companies, right? It affects their pockets. They lobby to keep it on the list that high, so it limits what's going to be researched. And they certainly don't want it to be used for medical purposes, right? Makes sense? States certainly can regulate what's happening within their states. So yes, marijuana is being legalized throughout the country in various states. But remember, state and federal criminal laws are independent of each other. And what may be legal in the state may not necessarily be legal under federal law. And realistically, though, feds have more important things to do than prosecute pot possession cases. So they are kind of allowing states to regulate the marijuana at the moment anyway. When Colorado passed the law making it legal, there was some question about what the feds would do. There hasn't been any action from the federal government, despite it still being illegal. All right, enough about drugs. So drug crimes: manufacturing, growing, possessing, distributing, selling, trafficking. And it's going to be dependent on where that drug falls on that drug schedule list, the drugs classification 1 through 5. Possession, how much drugs are possessed, and where. If we're talking about distributing or selling or trafficking, where are they being sold or distributed or trafficked to? Prostitution, another vice crime. And there's a link on Moodle to a video called Yardbirds. It's only a few minutes long discussion of prostitution. I think it's a fascinating review, so take a look at that. Should prostitution be a crime if both parties are consenting adults? It's based on a business transaction. And if you watch that video, that may change your mind relative to what you answer to that question. But only in Nevada is prostitution legal, and then it is strictly licensed with lots of guidelines relative to prostitution. In New York, and prostitution is a crime, but not only prostitution, but patronizing a prostitute, i.e. the John. The John could be arrested as well as the prostitute. Criminal act is offering, agreeing, or engaging in sexual conduct for money. That is the act. You can do it for free, and it won't be a crime. But the statute says money, so the question would be, well, what if you barter for something else? I don't know if they would constitute money. The statute says money. For criminal intent, it has to be general intent, knowingly. And in some instances, when we're talking about patronizing, it could be a strict liability, meaning there's no mens rea. I want to talk about prostitution in New York, the actual statute. I think I have a slide here. I do. Prostitution is a misdemeanor in New York. Under New York law, prostitution and patronizing, making an agreement to have sex, is patronizing, or sexual conduct with another in exchange for money. A prostitute is a prostitute. I should say, you can prosecute the prostitute or the John. And patronizing, as I said, prostitution is a misdemeanor. Patronizing, grading, elevates depending on those attendant circumstances. And the attendant circumstances is actually the age of the person agreed to have sexual conduct with. So, patronizing is a misdemeanor if the prostitute is 16 or older. Okay? The grade increases depending on the age of the prostitute. So patronizing is making an agreement. You have to just make an agreement to pay someone to have sex. You don't actually need the sexual act. And it's not just sex or sexual conduct. So it's at that point you make an agreement. So if the agreement is to pay to have sex with a 12 to a 15-year-old, that's a higher grade. We go to a felony level. And then if the patronizing is the agreement to pay to have sex with an 11-year-old or younger, that goes higher. And of course, if ultimately there's a sex act, we're talking about an entirely different kind of crime. Patronizing is making the agreement. So that, in essence, is prostitution. One more vice crime to go over: gambling. I guess we could stick being drunk in public, DWI. These are all forms of criminal acts or vice crimes. I think being drunk in public is obvious, and most of the time that's going to fall in New York. It's going to fall under disorderly conduct. And DWI, driving while ability is impaired, either by alcohol or drugs. That falls under New York's vehicle and traffic laws, but it's also considered a vice crime. But let's talk about gambling. The United States has long had criminal laws against certain forms of gambling. The unauthorized selling of lottery tickets has been a crime throughout U.S. history. Other offenses include the promoting of gambling, possession of gambling records, and possession of any equipment associated with gambling. There are certain forms of gambling allowed in some parts of the country, such as betting on racehorses, dog racing, casinos, and state lotteries. New York has criminal statutes relative to all of those activities if it's done outside of New York regulations, because we do have gambling in New York State. We have a lottery, we have horse races, and we have casinos, but they're all regulated, generally speaking. Dealing with the casinos that are on reservations, there are some restrictions. I am not even going to go down that route. It's not where I have had any ability to practice, but there is some government regulation, but it's different, being that it's on Indian reservation and outside the scope of what we're talking about. But let's talk about gambling as a vice crime. Generally speaking, gambling technically is not illegal in the United States. And I say that because there is no federal law banning gambling throughout the country. With that said, the bigger story gets a little bit more complicated. The U.S. does not have specific laws, but they do have this one specific law, the Federal Wire Act of 1961, and it actually prohibits gambling that takes place across state lines. So, placing a bet in a single state might be okay, but placing a bet with a bookie located in the state next door would be considered illegal. On top of that, sports betting was until recently extremely limited because of the Federal Professional and Amateur Sports Protection Act, passed in 1992. That law didn't make sports betting illegal per se, but it prevented states that didn't already allow sports gambling from legalizing it in the future. The Supreme Court actually overturned that federal law in 2018, once again allowing for states to make their own legislative decisions about whether or not to allow sports. Sports books is what they call them. Online gambling is also a big can of worms. The Unlawful Internet Gambling Enforcement Act of 2006 makes it illegal to operate an online gambling website anywhere in the United States. But it doesn't make it illegal for individuals to place wagers on an online gambling website. So as a result, there are a number of overseas gambling websites, Bet Online, and I think it's Bovita, something like that, that accepts wagers from Americans. And I'm going to note that online fantasy sports leagues, including daily fantasy sports platforms, are all exempt from this 2006 act. So it's up to states to make their own rules about gambling within their individual boundaries. That means that whether gambling is legal and what forms it can take vary depending on where you are in the U.S. Gambling is legal in some form. In some areas, actually in 48 of the 50 states, there's only 2 states that completely ban it. That's Utah and Hawaii. So Utah and Hawaii, no gambling. In Nevada, obviously, which is famous as a gambling haven, it is legal to gamble almost anywhere in that state. Most other states fall somewhere in between. For example, only allowing gambling at a licensed casino. In addition, many states allow some type of gambling, but not others. States like New Jersey allow betting on horse races on and off the track. There's sports betting and casino games at the same time in Washington. Horse race bets are allowed, but other types of sports bets are not. Furthermore, casino games are only allowed on Native American tribal lands in Washington. It's also important to note that local jurisdictions have their own say in whether to allow gambling if it's legal at a state level. Individual cities and counties also have the option to ban gambling or to prevent casinos from operating within their boundaries. So gambling is strictly a state crime, but notably there's a couple federal acts that are in there that have resulted in potential illegal gambling across state lines. Remember, feds will only get involved if it's intrastate or transcontinental. So that concludes the discussion on vice crimes and the complete chapter of Chapter 12. We have one more chapter to cover with crimes, and we will do that next week.